Hello everyone, and thank you to Judge Burgess and to Mary Brown, to the Family Justice Centre, for inviting me here today to speak to you. I would like to use the next 15 minutes to give you a brief introduction to the non-fatal strangulation offence and, importantly, to talk you through how the PPS are using this in our criminal prosecutions. So the offence of non-fatal strangulation or asphyxiation was created, as we've heard, at Section 28 of the Justice, Sexual Offences and Trafficking Victims Act, Northern Ireland 2022. And this offence came into operation on the 26th of June of this year, and any offending behaviour amounting to non-fatal strangulation or asphyxiation and committed from that date may be prosecuted under this offence. The offence is not retrospective, so this means that any of these behaviours committed before Monday the 26th of June will still need to be prosecuted using other existing criminal offences. And as the title of today's event states, non-fatal strangulation is certainly not a new phenomenon. Victims of domestic and sexual abuse have been experiencing these types of assaults for many, many years. And as Alison said, forever. And PPS have regularly seen evidence of non-fatal strangulation in the domestic abuse and sexual assault files prior to this offence coming into operation. Through your areas of work, you may know that choking has been recognised as an offence in our jurisdiction since 1861 under Section 21 of the Offences Against the Person Act. That is, the offence of attempting to choke with intent to commit an indictable offence, for example, rape, robbery. But this offence had not been without its difficulties. To successfully prosecute under Section 21, that offence requires proof of intention to commit another serious indictable offence. With the passage of time, and as non-fatal strangulation has developed into a weapon, a cruel tactic by a perpetrator to exercise dominance and control or intimidation, this has created a legislative gap. Prosecutors had often found that such proof of intention to commit another indictable offence, for which domination and control would not readily qualify, was frequently unavailable. As a result, prosecutors are then required to charge strangulation as an aggravating factor in the prosecution of an alternative and often lesser offence. And in doing so, this had failed to capture the prevalence of strangulation. It failed to send a signal about the seriousness of this form of offending and meant that that type of offending was not appropriately sentenced. It also made it difficult for prosecutors, police and the courts to identify those offenders who posed a serious and significant risk of committing further and often more serious offences, murder, attempted murder. And you'll see there that the proof is in the data. Despite the prevalence of non-fatal strangulation in today's society, PPS have only been able to prosecute the Section 21 choking offence 33 times since the PPS was established in June 2005. And so the specific offence of non-fatal strangulation is extremely welcome as it removes those hurdles associated, as I've mentioned, with the Section 21 offence and more accurately reflects the risks associated with these acts that we will be touching on throughout today. So moving on to the new offence, the offence can be committed in one of two ways. The first way is where a perpetrator, and we'll call them A, intentionally applies pressure on or to the throat or neck of another person, B. Examples of that we've already heard, but those examples include a hand or hands held around the neck of another person, a chokehold, a headlock, a ligature, for example, a belt or scarf around the neck, and pressure on the neck from the foot or knee. The second way in which the offence can be committed is where the perpetrator A does something to B of another sort, amounting to a battery of B. So this is where physical force is applied to areas of the body other than the neck, which could impede normal breathing or circulation of the blood. And some examples of this include gagging, putting a hand or object, such as a scarf or pillow, over the mouth and nose, suffocation, for example, putting a plastic bag or pillow over the head or face, compressing the chest, any force or suppression applied to a person to cause a restriction of breath. Now, as well as the physical act itself, prosecutors must also consider the perpetrator's mental state at the time of the act. We must prove that A intended to affect B's ability to breathe or the flow of blood to B's brain, or that A was reckless as to whether B's ability to breathe or the flow of blood to B's brain would be affected. To prove intention, prosecutors will be looking at the context and background in which the offending is carried out and any words said by the perpetrator. Where we don't have sufficient proof of intention, prosecutors may alternatively be satisfied that the perpetrator was reckless and that when committing the act, the perpetrator took an unjustified risk as to whether the victim's ability to breathe or the flow of blood to the victim's brain would be affected. And we know from the extensive research in this area how little pressure or force is required to cause those effects. Significantly, and what we feel are the real strengths with this offence, are that the offence is committed irrespective of whether the ability to breathe or the flow of blood to the brain is in fact affected. It applies irrespective of how the act is done, for example, by use of a hand or another part of the perpetrator's body. And there is no requirement to prove the perpetrator had an intention to cause an injury or that any injury was caused. And this is particularly significant as we know in many cases there may be no visible injury to the victim. We are really hopeful that these factors will assist PPS prosecutors and police to take more prosecutions for this offence through the courts. The legislation provides a statutory defence to this crime, and it will be a defence to show the victim consented to the strangulation or other act. But importantly, this defence will not apply if the victim suffers serious harm as a result of the strangulation or other act, and the perpetrator either intended to cause serious harm or was reckless as to whether serious harm would be caused. And serious harm means injuries that may be prosecuted as assault occasioning actual bodily harm, and those more serious non-fatal offences under the 1861 Offences Against the Person Act. I should also point out that where the offence is committed outside the UK, for example, on a foreign holiday, it can still be prosecuted by courts in Northern Ireland if the act would constitute the offence if it had occurred in Northern Ireland and the person who does the act is a UK national or habitually resident in Northern Ireland. The penalties for this offence in Northern Ireland: if the offence is prosecuted in the Crown Court, offenders can be sentenced to a maximum of 14 years imprisonment or a fine or both. In the Magistrates' Court, it's a maximum 2 years imprisonment or a fine or both, and that's one of the highest possible sentence available in the Magistrates' Court. And by contrast, in England and Wales, the maximum sentence available in the Magistrates' Court for their non-fatal strangulation offence is 12 months. So we feel really, really lucky that we have such an important high bar set for sentencing. These are harsh sentences, and they reflect the tough message that we wanted to send out to perpetrators when convicted of this type of offending. And just on that point, I would like to highlight some judgments coming out of our courts in Northern Ireland in recent months where non-fatal strangulation has been present. In April 2023, the Court of Appeal in Northern Ireland delivered a judgment in the case of the Crown and Dylan Mulholland. The appellant in this case had been drinking at the victim's home when an altercation occurred in August 2019. During the course of the incident, the appellant punched and slapped the victim around the face. He then proceeded to strangle her until she passed out. She was also kicked repeatedly to the body, with the assault lasting several hours. The original charge of grievous bodily harm in this case was dismissed, but Dylan Mulholland was convicted of assault occasioning actual bodily harm, and it was held that a sentence of 5 years imprisonment for that conviction was a reasonable approach to take. In another recent Crown Court case of the Crown against BN, the defendant entered a guilty plea and was sentenced to 6 years imprisonment for a number of offences, including assault occasioning actual bodily harm, the Section 21 choking with intent to commit an indictable offence, namely rape and attempted rape. In sentencing the defendant in February 2023 to 6 years imprisonment, His Honour Judge Rafferty remarked, "Non-fatal strangulation must be clearly understood as a very serious offence in its own right. It is a terrifying experience for any victim, and deterrent sentences are required not just to punish the offender, but to deter others. Non-fatal strangulation in a domestic violence setting must be carefully examined by the police, the Public Prosecution Service, the Probation Board for Northern Ireland, and the courts. It is a statistical red flag for femicide and operates at all levels in the assessment of future risk." The offence of non-fatal strangulation has now been in operation for over 5 months, and in that time we have seen more than 200 files with charges of non-fatal strangulation coming into the PPS from police. The majority of these files are currently with our senior public prosecutors, awaiting decision to be taken. But as of today, we have already taken 22 perpetrators to court for this offence. One of those being taken to the Crown Court due to the serious level of injury caused to the victim as a result of being strangled. We have cases of women being choked by their partners and ex-partners, mothers being choked by their sons, and men being choked by their brothers. We have also seen our first conviction coming out of the Magistrates' Court recently, with the perpetrator receiving 6 months custody after being convicted of this offence, where pressure was applied to the victim's neck for a couple of seconds. In the PPS, we take this offence extremely seriously and are committed to holding perpetrators to account for this dangerous form of assault. We have invested heavily into training all of our staff on this offence and recognising the grave dangers associated with it. We have issued detailed internal guidance for our prosecutors on this new offence and how it should be charged. Prosecutors will consider this offence in every case where there is evidence of non-fatal strangulation or asphyxiation. We know that this type of offending is most common in cases involving domestic abuse or sexual assault, but it will also be applied to all case types where the evidence supports it. Going forward, where there is sufficient evidence to prove non-fatal strangulation or asphyxiation, prosecutors will be charging this offence in preference to a common assault, even in cases where there is minimal or no injury evident. Where there is sufficient evidence that assault occasioning actual bodily harm has occurred as a result of strangulation or asphyxiation, prosecutors will be charging the non-fatal strangulation offence. This will ensure that we mark the seriousness of this type of offending and the increased risk of future lethality on the defendant's criminal record in the event of a conviction. Thank you for listening.